accident.
No one sees him driving.
He was just parked across the street.
No, no, what, really?
He made the statement that
I get it.
he was in the vehicle and he made the statement.
I took a shower today, I mean, you just make a statement. I mean, no, there's no proof.
To having knowledge of the suspension, and he was in the vehicle parked across the street.
But no one sees him driving.
The 228th and reckless driving.
He has another robbery here?
Yes,
That's local?
yes, it's a robbery
Open?
threat in the 228th. It is open. He's made bond on that.
Two-way road. So he was out.
On earth are you gonna know that you're parking more than 18 inches? What time of day or night was this?
Your Honor.
Of the state of Nevada, specifically Clark County, for a robbery. And you are asking me to set you a bond. Is this right? Okay. I don't know anything about you. I'm now getting to know you for the first time, so I don't know. My primary concern is, are you a dangerous person? Because, I have so much drama in my life right now. It's ridiculous. I just don't need any more. And what I don't want to do is release you if you are a danger to my public, because I cherish that, right? I don't need any more. So we're going to find out a little bit about you, and then we'll see where we go from there. Amy, let's get to know Mr. Jefferson.
Yes, so he's wanted in Clark County, Nevada for conspiracy to commit robbery, and theft value over $100,000 or greater. The state's opposed to a bond at this time. He, as the court knows, he's being held. Well, he's not being held. He's made bond also on robbery threats in the 228th and reckless driving.
He has another robbery here?
Yes,
That's local?
yes, it's a robbery
Open?
threat in the 228th. It is open. He's made bond on that.
Okay.
So you got a robbery there. You pick up a robbery here too. It's a robbery.
This warrant was also issued December 18th, very recently.
When was bond posted, if you don't mind on that?
Yeah, let me look.
He's actually, he's on bond. He's on bond for reckless driving.
Okay.
Picks up a robbery here in September. So I guess he's on bond for a robbery here. And now he's picked up another robbery in Nevada.
I thought the robberies in Nevada were old.
He
Oh,
made
she said they were just issued 12/18.
He made the bond for the robbery threats on September of this year. That case was filed also September of this year. And then this new warrant was issued this December. His reckless driving was,
What court is that out of?
that was the
28th.
28th.
No, the reckless driving.
Oh, this one's out of court 10.
What's the court date on that?
That is
January
on January 30th.
He has a general order bond on that.
Yeah, he's made bond on that one. He also has made bond on the robbery.
And he's made court, has he made, my question is, if he's made his court appearances, Your Honor, I mean, I think he's proven that he should go into court, showing up to court. So if you did consider bonds, he could then, don't worry about the reckless driving.
The state also wanted to add that he was just barely out of parole from earlier this year.
He was what?
Barely out of parole from earlier this year, as they have.
What was he on parole for?
That I don't know exactly.
Mr. Jefferson, I got to be frank. You scare me, man. You continue to pick up cases, and they're serious cases, right? Second-degree felony. I don't know, maybe this is a third degree, but nevertheless, you have a robbery here, you pick up a robbery over there. That scares me. If I let you out, are we going to get a third one? I don't want that to happen. I know you're telling me no, but history tells me otherwise. All the open cases tell me otherwise. Now, I do have some good news for you. The good news is that you've made bond on these two cases here, so there's no holding pattern, meaning that Nevada has 14 days to come get you, and if they don't come get you, then Harris County releases you. So you have that going for you now, but I just don't feel comfortable giving you a bond. You scare me, man. The last thing I want is a third robbery. Do you understand? You gotta understand from my perspective, I don't know you. You're telling me all these gumdrops and rainbows and bunnies jumping in the woods, but you've got all these 3 open cases. They're serious. Sorry, I can't, I mean, just,
Okay, he signed on Monday, Judge, so I guess,
so.
can we reset it to, what is that, the 8th?
Case, right, Monday, so 1, 2, 3 days have passed. So you got another, what, 12 days, give or take?
So can I get a reset for the
2, 3, 4,
8th?
5.
Is that correct? If I'm counting it?
The 7th.
The 7th, even better. Okay.
Yeah, so, you said the 23rd?
He signed on Monday, the 23rd is my understanding. So I think the 7th.
Yes, the 7th.
So if they're not going to get you on the 7th, you'll be released in Harris County.
So they have until the 6th to come get you, okay? If they don't come get you by the 6th, then on the 7th, you'll be released. But you got to understand, even if we release you, that warrant will eternally remain open. And you could get picked up again the minute you walk out of custody. If you do get out, I would immediately go back to Nevada, take care of that. Otherwise,
Yeah.
at some point, you're just going to get picked up again, and it's going to continue to happen.
You can hire an attorney.
And the other thing is that, right, when you do go up there, you got to let your attorney here know what the plans are so that you don't get revoked upstairs here, because then you're going to be in the exact same situation over there like how you are here. You understand? So if you go over there to Nevada and try to handle things and they put you in custody and no one knows about it here in Harris County, you have not advised your lawyer, they may think that you've just jumped ship and they might revoke the bond here, and then they'll place a hold here in Harris County because you're in Nevada. And if nobody knows, you know what I mean? So you got to let your lawyer know here.
You're a misdemeanor lawyer on your record. Do you have a lawyer for both of them, or were you appointed lawyer? Okay, so you need to tell your lawyer that if they don't pick you, you need to contact him, let him know you're in custody. If he doesn't
He
know.
has a lawyer in the felony, so
Yeah.
let your lawyer know in the
You
felony
need to let
case.
him know, and if they don't pick you up, you need to hire someone in Nevada, try to get you bonds on those, or you're gonna have to go out there and address them and turn yourself in and then see if they give you a bond.
All right.
So if they don't revoke your bonds here, you need to let your attorney know. You understand all that? All right.
Okay, man. Good luck.
Thank you, Ron.
Thanks, Ray. Good morning, Mr. Rodriguez. Sir, you were charged with assault, bodily injury, and criminal mischief. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You're facing up to a year on both of those cases and/or a $4,000 fine.
Judge. On December 24th, 2024, the officer was dispatched to the location and made contact with the complainant. The complainant stated that he followed the sister when she left the house to try to get her to come back. That's when the complainant ran into the defendant, the complainant's sister's ex-boyfriend, and told the defendant he could not be around his sister. The defendant walked up to the complainant really close, and the complainant pushed the defendant to get some space, and the two then began to get into a physical altercation. The complainant stated the defendant bit the complainant's left arm in between the altercation and then ran away. The complainant complained of pain and was advised by EMS to get stitches, and then the defendant was ID'd with mobile APHIS.
You said this was a sister as the complaining witness?
No, Your Honor, the sister was the ex-girlfriend of the defendant. The brother was the complainant.
Got it. Okay. Tell me about the criminal mischief.
On the criminal mischief, on December 18th, 2024, the officer was
So same day.
same day, Your Honor. No, it was before. The assault was on the 24th, the criminal mischief was on the 18th. So on the criminal mischief on the 18th, the officer was dispatched to a residence in Harris County, Texas in regard to a disturbance. The officer made contact with the complainant, who stated that the defendant broke his window with a rock. The officer made contact with a witness who stated that on the 16th, he observed the defendant throwing a rock at the front window, breaking it. The defendant was then observed by the witness leaving the area, returning to the side of the house, and throwing a bigger rock at the side window, causing it to shatter while also trying to enter the home through the window. The damage to each window was approximately $1,200.
Both of these happened on the same day, right?
No, Your Honor. The assault was on the 24th, and according to the witness, the criminal mischief was on the 16th of December. So the criminal mischief occurred before the assault.
But I'm looking at the information. The information says December 16th on both.
There is a second assault, Your Honor.
What?
There's one.
On the 31st.
Yes. Oh, okay. My apologies. I was reading the because he was just picked up an assault. Let me read the assault that's out of the same transaction, Your Honor, because he picked up another assault, and that was my apologies. So for the assault on the 16th, the officers were dispatched to a Walmart in regard to service for a disturbance. And the defendant was taken back to the original scene, and the officer spoke to the complainant, who stated that he went looking for the defendant because he was a person of interest in a previous incident. While waiting for police to arrive, the defendant tackled the complainant to the ground and held him in a rear chokehold for approximately 10 seconds, impeding his breath. The complainant stated he felt pain and suffered minor injuries to his person, including a scrape on his left knee, a scrape on his right elbow, and a swollen upper lip. A witness, the complainant's girlfriend, witnessed the incident and saw the defendant choking the complainant. The defendant also admitted to placing the complainant in a chokehold.
All right, Mr. Rodriguez, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If you have a problem with drugs and alcohol, you better address it, because I'm telling you now.
No, it's not a problem, sir.
Look at me. If it becomes a problem, I'm going to address it for you. And I promise you're not going to like the way that I do it. Do you understand? I'm going to test you heavily.
That's fine.
What's the name? What is your name, sir?
Mark.
Mark. Hi, Mark. Nice to meet you. I'd like to send Mr. Rodriguez for a drug test right now, please. Stop. Don't say anything.
I consume marijuana.
Stop. I'm sending you for a drug test now. I'm gonna have you come back. I want to see what's going on. That's it.
Okay. All right.
But come back. I'll give you a lawyer today. I want to know what's going on with you so that we're both on the same page.
I can tell you.
Don't say anything. Stop. Stop. Go take the test, and I want you to come back. I'm going to appoint your lawyer today. As far as your bond conditions are concerned, you're not to have any contact with the complaining witness in this case, not to go where they live, where they work, where they breathe. You're not to be in possession of any weapons. Do you understand? If you violate these conditions, you know what's going to happen. Do you understand? All right, please. So don't worry about conditions, because I'm going to have a monitor.
Yes, Judge.
Judge.
5002.
I'm Courtroom Rodriguez. He's on today's law office.
Okay, great. Come up, sir.
And we have those results.
Great.
Judge, David presented positive for THC, amphetamine, MDMA, cocaine, and methamphetamine.
Is there something that's not, I mean, really? Stop. It's a rhetorical question, Mr. Rodriguez, but I'm going to tell you now, it stops today.
Sure.
We're going to do this the easy way, or we're going to do this the hard way. I am giving you the opportunity for you to try to do this on your own. If you are incapable, then you're going to stay with me, and we will do it the hard way. Do you understand?
Yes, Your Honor.
You will be required to test bi-weekly here with me, so I know that you're not using. And if you show me that you can stay clean, then I will stop. But we will do this in baby steps. But for the time being, you're going to stay here and test a lot with me. Do you understand? I will give you a pass of 45 days on the THC, 45 to 50 days on the THC.
Sure.
But if after that time you continue to test positive for marijuana,
Right. Yes, Your Honor.
I have given you a lawyer. It is your responsibility to stay in touch with Anna. If Anna tells me she can't get a hold of you because you play games, likewise, the bond will go bye-bye.
Yes, Your Honor.
All right? Okay.
Thank you, Judge. We'll see you on
All right,
Monday.
Mr. Rodriguez, see you Monday.
Yes, Your Honor.
Thank you. Can you be excused?
Charged with driving while your license is suspended, you're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On December 2nd, 2024, officers were dispatched to a minor accident on Sam Houston Parkway. Upon arrival, the officer met with both parties of the accident as well as a witness. The witness advised that there were minor disturbances on the scene in which a knife was brandished by the defendant who was parked across the street from the accident. The officer identified the defendant and discovered he had a mandatory suspension on his driver's license for a second DWI. And the defendant advised that he had still been driving for work. He had personal business despite having personal knowledge of the suspension. The defendant stated he was driving from San Antonio and was only waiting for his coworker who was involved in the accident.
Does he have an open DWI right now?
Does not appear so, Your Honor. It appears that the last DWI he had was in 2019 out of Bexar County.
Bear.
Bear County, yes, Your Honor.
Okay, Mr. Patlan, I want you to understand one thing. I'm going to find that there's, so wait a second, someone saw him driving or did the officer see him driving? Because I didn't,
He admitted that he had been driving for work. And he admitted to having personal knowledge of suspension as well.
did anyone see him driving?
No, Your Honor, there's only the
Do we
statement.
know even when he was driving?
There was an accident. That's what dispatch involved. And then
Okay, so, all right, okay, so,
there was an accident and then officers arrived and then they made contact with the defendant.
got it. So all this was in response to an accident that he was allegedly involved in.
Yes.
Got it. All right. So I am going to find probable cause, Mr. Patlan. And no, don't. You have the right to remain silent, exercise. I've got about a bunch of DAs here. Anything you say, they're going to use it against you. But let me make something abundantly clear to you. I'm going to have you sign with me today an affidavit. This is a promise that you're making to me that you're not going to drive. I don't care what is going on in your life. When we mean no driving, we mean no driving. I don't care if there's a burning building and you have to save 50 kids. Do not drive. If you do, I can have a contempt hearing facing up to 6 months in jail and a $500 fine every time you drive. Do you understand? I don't care what your excuse is. You cannot justify at all any reason. If you want to drive, go get a license, get liability insurance, and then we can talk. But until that point, I will even do this. This is the number to the DPS driver's license division. If you call them, they can tell you exactly what you need to do to get your license back.
Classes now, sir.
There may be, an SR 22, you may have to do all these other things. What you need to do is call them and they can advise you, but don't drive. Do you understand?
And Your Honor, I do have to make a correction. After reading the full DIMS, the defendant was parked across from the accident. It was his coworker that was involved in the accident. He was parked across, Your Honor. And I do apologize. After reading the complete DIMS, the officer wrote that the defendant was parked across the street from the accident, and he made a statement that he was waiting on his coworker who was in the accident.
No one sees him driving.
He was just parked across the street.
No, no, what, really?
He made the statements that he was.
I get it.
He was in the vehicle and he made the statements.
I took a shower today, no, you just make a statement. No, there's no proof.
To having knowledge of the suspension, and he was in the vehicle parked across the street.
But no one sees him driving?
He did make a statement.
No. To be with your mom? Okay.
I separate
Got it.
family and spectators.
Okay. Good morning, Mr. Hardy. Mr. Hardy, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. Shh. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge.
Okay.
On November 22nd, 2024, the officer observed the defendant's vehicle parked more than 18 inches from a curb on a public roadway in the right lane of a two-way road in Harris County, Texas. While the officer ran the motor vehicle, the passenger side door opened, a black female exited, and the female approached the patrol vehicle. The officer made contact with the female and observed a strong odor of marijuana emanating from the female. The officer made contact with the defendant, the driver of the vehicle, and observed a strong odor of marijuana and had the defendant exit the motor vehicle. A PC search was conducted and the officer located 3.5 in the driver's side door and one blue package with Oops All Berry on the front containing green leafy substance on the rear driver's side floorboard, one red package with Fruity Pebbles on the front containing a green leafy substance in the back seat, and two clear plastic baggies containing green leafy substance under the front right passenger seat. The officer also observed one burnt marijuana cigar behind the front passenger seat and one small chunk of loose green leafy substance in between the driver's seat and the door. The green leafy substance was identified as marijuana based on training experience, and the weight was 54 grams or 1.9 ounces.
He was doing what that was wrong?
So he was parked more than 18 inches from the curb on the right lane of a two-way road. So he was out.
On earth are you going to know that you're parking more than 18 inches? What time of day or night was this?
Your Honor.
Is it parking while black now? Come on.
Your Honor, there's no time listed. It just says the officer was on patrol around the 3518 block of Arbor Glen Drive when he observed the vehicle parked more than 18 inches from the curb.
And so he goes up to the car because of that?
No, Your Honor, a female passenger side exited the passenger side and approached their vehicle, and he observed a marijuana.
Well, but because he comes up to them. Right? Stop. Are you losing?
The officer wrote as he ran the vehicle, presumably the license plate.
Right, he pulls him over.
They were already parked on the side of the road 18 inches from the curb, and he came, I guess, parked behind, and he was running the vehicle, and then the passenger side door opened, a black female exited and approached his vehicle, the patrol vehicle, and he observed an odor of marijuana on the female, and then he made contact with the driver, where he observed marijuana odor in the vehicle. So the female approached the patrol vehicle.
Show me in the penal code that code. What is the penal code for that?
Regarding the 18 inches from the curb, sir, is that the
Yeah.
issue of what we're talking about?
Yeah, because they come to him because he comes to them. Right, they're just parked. He comes to them. It's got to be a transportation code, not penal code, you know?
And Your Honor, regarding the timeline of events, it does appear that when they were parked that distance away, which could be arguably further, I don't know what it looked like at that time, but the female passenger is the one who exited first, and that was before officers ever made contact with them. So I don't know if you were thinking that the officers approached them first, but I just wanted to clarify that she approached first.
What time of day or night was this?
Trying to see that, Your Honor, in a second.
Is it 4 in the morning?
And Your Honor, I
4 in the
found,
morning.
4:30 a.m.
And he can delineate at 4 in the morning that parking 18 inches from a curb.
and I found the regulation, the statute in the transportation code where it says you have to park within 18 inches.
At 4 in the morning, you can tell.
Your Honor, the officer was,
Yeah,
yes.
I don't think so. All right, I'm going to find no probable cause.
Yes,
All
Judge.
Guys, be careful, right? You know, they're always out there. Just be careful.